Okay, a very good afternoon to everybody. First of all, thank you for joining our webinar. And as you guys know, we are going to conduct the webinar on India's data protection bill. So a few things before we start the webinar. This webinar is going to be conducted for an hour, out of which 45 minutes would be the context of the entire webinar, and then in the end 15 minutes we will have a quick Q&A section, and we'll run a poll. In the Q&A section, if you guys can see, there's a Q&A box. So at the end of the webinar, if you guys have any questions related to today's webinar, you can post it in the Q&A box, and then Mr. Ashwin, who will be leading the webinar, would be answering those questions one by one. And simultaneously we'll be running a quick poll, and we'll just wait for everybody to complete the poll. So yeah, this is about today's webinar. Also, I would just like to inform you all about our training programs. So Asidyo also conducts training programs for lead auditor and lead implementer in ISO IC 27001, which is the PIM standard. And you can contact us if you guys have, any of you want to get trained either in lead auditor, lead implementer. You guys can directly contact us. And also, lastly, before Mr. Ashwin takes over, we also have another webinar coming up on 1st March. It is completely focused on the new amendments in ISO 27002. So if you guys want to join that, you guys can register. And if you do not have the link, you guys can email us. I'll send you the registration link. Once again, thank you. And Mr. Ashwin can take over.
So thank you, Eva. I think everybody can see my screen, right? The PPT. Okay. So thank you once again, and welcome to this session, important session on the India's data protection bill and how the PIMS can help. That's our subject today, and let's see on this webinar how it's going to help. So in today's session, we are going to do a quick introduction about us, the context, India's data protection bill, which is the updated one 2021, and what is PIMS and how the PIMS implementation certification can help us all. So I'll just play a video about our introduction. Okay, so that was a quick introduction on video, and just to reiterate that we are a CPA firm ourselves, focusing on data security and privacy. We are listed with Cloud Security Alliance, listed with PCOAB. We also an accredited certification body covering data security and privacy audits for now. So there are only few companies worldwide that can provide a SOC 2 and ISO certification under one brand. Countable 10, 15, whatever. I just don't have the exact number, but it's not more than these. And SCDL is one of them globally. And also Cloud Security Alliance has only a list of about 15 odd auditors globally, which we are one of them. So my background, I am the CEO of SCDL. I run both the operations in the US and in India. And I've been in this auditing business, cybersecurity audit business, and information security business since 19 years, in this field rather, since 19 years. I'm a qualified CPA and MBA, and I hold some of the global certifications in cybersecurity, such as CITP, CISSP, and so on. I've been focusing on across the areas of cybersecurity and information security in my 19 years of journey. And SOX compliance, SOC reporting, SSE 18 or SAS 70, it was called at that time, cloud security and privacy full time for the last 5 years. Before that, cyber security, application security, VAPT, industrial cyber security, and so on. Many of you know me. Some of you who joined are my friends, my clients, and etc. So today's context is we are seeing that there's increasing cyber crimes. The cybercrime market is poised to be at about $10.5 trillion, which is as near as the US economy per se. And 63% of all data breaches are directly linked to third parties. 80% of all data breaches have PII data, and there's a 140% increase in data breaches generally on a year-to-year basis. Right? Cloud services is going up, and that's an important factor. It's going to go to 947 billion by 2026, right? Growing at the rate of more than 16%. 93% enterprises already have a cloud strategy. 82% of the organizations use third parties for data processing. And only 30% organizations respond to data subject rights in less than 2 days or in about 2 days' time. So that's some of the figures that we need to look at. And that is the reason this is so important, and that we need to address or need to look at this area in terms of data security and privacy to safeguard ourselves, our organizations, individuals, everybody. Now, privacy has been gaining importance since the last few years, specifically when GDPR came into the picture. If you see the fines, Facebook 5 billion, Equifax and British Airways, if you see all of these are ICO or GDPR based fines. And that's the reason it has gained importance. As far as SEDO is concerned, we have been working on privacy since the year 2012. Personally, myself also. So it so happened that the AICPA, since I'm a CPA, AICPA was one of the pioneers in creating a generally accepted privacy principles framework itself, right? Which was adopted by many regulations per se, including GDPR, the Canada, etc., etc. So that generally accepted privacy principles has been there since 2008, right? And I got involved into privacy full time almost since the year 2012, when I also published an article in the ISACA magazine on privacy compliance on when BYOD. When that time all the BYOD was a big, um, uh, I mean, a big move that people use their own personal devices, mobile devices for use of corporate data, and privacy was a big concern. So that was one of my articles in 2012, and since then we have been working on privacy. Privacy is not new to me and our company. We have been working on it, and since 2008 we have this framework, AICPA framework. Being a CPA, we have been deliberating on it. We have implemented and audited GDPR compliances, etc. So it's not only the fines which is important. Privacy is important from a difficulty perspective also. It is not easy to achieve privacy like security. I would say security is one layer, but privacy is 4 times more difficult to even achieve compliances in its entirety. And that's the reason you see so many fines, right? It's because it's difficult for companies to achieve because there are several angles, several data angles, and it's one of the difficult tasks. And that is the reason even today we see that less than 50% companies are still not compliant with even GDPR. And that is the reason we chose to have this session, this webinar today, because we are expecting the data protection bill in India, and it's going to take some time for us to, or the organizations to comply or understand and come to that. It's not that that we will start acting upon it once the act comes into picture. I wouldn't suggest to do that, because if you wait for it and then start acting upon it, right, you might take 3 years, 4 years to even understand that and adapt it into your entire organization. I know of some organizations who tried to achieve privacy within 1 year's time in terms of compliances, but they couldn't do that easily because it requires understanding, dedication, devotion of time, resources, etc. Some of these cybersecurity folks like us, we understand it, but when it comes to getting resources from the management, right, we need to convince them again and again, because some of those management people may not be cyber aware or privacy aware of how difficult it is to reach to them. And getting the resources from the management or getting their buy-in becomes a difficult. And so it is good for us if we can, get to the management from day one that, sir, this is coming. This is already in the parliament. It's already going to take shape. We have been deliberating since almost 2 years when the first data privacy bill was tabled in the parliament in 2019. So there has been a lot of deliberations, there has been a lot of things going on, and I feel rather that this should be done soon, and it is high time for us to get ready to take the challenges which would come out of this bill, which becomes an act sooner or later. So coming to India's data protection bill, there have been some changes in when it was last tabled in December. So just to have a disclaimer here, we are an audit firm, as you've seen from our introduction. We are not a law firm, and whatever we are going to discuss today would be pure from an audit, compliance, and PIMS perspective, and not from a law perspective. So I will not be addressing any law-related questions. I'm not a lawyer. I'm not authorized. I'm not, not only authorized, I not even have that caliber to think in a lawyer's terms. Being an auditor in terms of compliances, we do understand how some of those controls, which are included in the law, can be applied and can be converted into controls. So that is our specialty, right? We are not a specialized law firm. We are a pure audit firm, and our specialty is only how those requirements can be converted into controls and to make sure it's compliant in terms of technical and not only technical, in terms of people, process, and technology, all the aspects. So that will be our focus today. And if there are any questions from law point also today, I will not be able to take them. If there are any questions on people, process, and technology and how to apply them and how to use them in terms of compliance, yes, we can address those questions. So why does India need a data protection law? India's endeavor is to reach a 5 trillion economy, and that's the reason they are looking for having a data protection law. And we want companies to be accountable. And we have seen the right to privacy by Justice Puttaswamy Swamy. We have seen the Sri Krishna committee report that privacy bill is required since the last 2 years, and it's time that this should take shape soon, right? So that is a context, and data is the oil, and data is the is converted into dollars. Data is bought and sold in the dark web for money. We have ransomware attacks for taking out data or for selling out data. We have intellectual property, which is again data. There are several tasks, and of course, when it comes to personal data, of course, we have our personal lives. We see that a lot of telemarketing calls, misuse of data by even some of the private institutions and even government institutions or semi-government institutions do happen. Data is not used for the purpose it is taken. That is a big challenge. Like GDPR had this challenge, and that is what this law plans to tackle. So the quick salient points that it will be applicable both to public and private entities within India, by state, non-state, foreign entities within India, data fiduciaries. We'll come to the definitions in the next slide. Data fiduciaries, data processors, not present in India, but also having connection with some business in India. Social media platforms has been a great motivator to come to this bill also. Now, before we move forward, let us understand the terminology. Now, since the Data Protection Bill India, which is the 2021 version, moved from 2019 version. So earlier that was a personal PDP called Privacy Data Protection Bill in 2019. The terminology has been changed to Data Protection Bill only now, because they have now tried to include both personal and non-personal data. So this bill is looking at both personal as well as non-personal data, and the new name is Data Protection Bill 2021. So looking at the terminologies, it's being used in this bill is data fiduciary. If you map to the terminology of GDPR, why GDPR? Because if you see the Joint Parliamentary Committee report, a lot of references to this is given to GDPR because it is inspired by GDPR also. So in GDPR terms, we may call it as data controller, right? So data fiduciary is a term we use in the Data Protection Bill 2021, and the equivalent term may be a data controller. The ISO 27001 also uses a data controller term because even that is mapped to GDPR. Data processor is the same data processor here and all the three places. Data principal is used for individuals. For individual data, personal data, they use the term data principal, whereas the GDPR uses the term data subject, right? The ISO 27701, which is the ISO standard, uses the term PII principal, or again the principal. So these are the three major terminologies, because we will be talking about these terminologies across the slides. So it's important that we understand about this. Now coming to Data Protection Authority, it is in this bill and also within in GDPR. Data Protection Officer also is in both the places. There is no specific because ISO is a standard, is not a requirement, so they don't mention anything about specifically about the authority itself, right? So the obligations of data fiduciary is much like the GDPR. Personal data must be fairly and lawfully processed, must be processed for limited purposes, must be data subject or data principal rather, yeah, should be notified, and it should be accessed in multiple languages if necessary. Data can be, I mean, it should be adequate, relevant, and not misleading. Collection should be rather relevant and not misleading. Data must be accurate, up to date, and should not be kept longer than necessary. Data can be transferred to other countries only when authorized by the state, right? And data processing should comply with the bill. Some of the highlights. Now, again, personal data is a piece of information where reference can be drawn to identify a person, which we call it as an individual, or the data principal, which is called in the bill. Right? They have a right to information. They have a right to portability. They have a right to be forgotten. They have a right to be correction, etc. Now, also some of the features are that data can be processed only for specific, clear, lawful purposes and with explicit consent. That is a term also being used like GDPR. Exceptions could be some medical emergencies or legal proceedings which will be notified. Government could exempt any agencies from the provisions of the bill in the interest of national security and safety. That is what the bill states. Restrictions on transfer, there would be restrictions sensitive to the critical data. They say should be processed only in India. Sensitive data can be transferred only with the individual consent subject to state uh, directives, and it should continue to be stored in India. That's what is the requirement. Obligations of data fiduciaries would be to have a fair and reasonable data processing, purpose limitation, collection limitation, accountability, lawful processing, etc. Data fiduciary is also responsible to implement safeguards such as data anonymization, encryption, etc. So it's important also to note that the bill also provides that if the data is anonymized, right, it is not part of the scope of the bill. So it's important that we use people, process, and technology into our environment so that the data can be anonymized, and thus we don't fall in the purview of the data protection bill if we can do that. However, it is easy said and difficult then done. We will see in the next slides also, but just to highlight that why it is difficult, because many of the environments do not have currently a data inventory. We do not have data flow diagrams. We do not know where our data is stored. We do not have a data governance system. Data governance will come only when we have a data flows. We know where the data is stored in flat files, in databases, in reports, in Excel files, in SharePoints, in the cloud, with the business, with the IT, with business units, etc. There is no data governance mechanism. There is no data, what do you say, even visibility of the entire data per se to have a governance in majority of the organizations till date. And that is the reason you see as a privacy as a challenge, because data visibility is not there currently in majority of the organizations. And that is the key challenge. And because we don't have the visibility, we are unable to do a risk assessment. We are unable to implement safeguards, right? And that is a long process. It's not done overnight. Just because I have a privacy policy, I have a cookie policy on my website, it does not make us privacy compliant. It does not, right? I have been an auditor to some of the Fortune 100 companies for privacy, and I know that it is very difficult for organizations to achieve privacy. And we recommend organizations to take their time in implementing the controls first before they come to us for getting audited. We get requests from companies, sir, we have a privacy policy, we have a cookie policy, please come and audit us. It doesn't work that way, because at the end of the day, we are not consulting companies. We cannot go and implement the controls into your environment. We can only guide you, we can only tell you what you need to do and how you need to do. You still need to do it yourself. As an auditor, ISO auditor and SOC 2 auditor, we have restrictions that we cannot do consulting directly to you, even if you want to do that, if you are an audit client for us. However, if you're not an audit client, we could still look at that option, but if you're an audit client, we cannot do that. And that's the reason we are having these webinars to address this in advance to all the clients. Please don't take privacy lightly. The bill is there, the act would come, which it's important for us to get ready today. The next point is institute mechanism for age verification. The data fiduciaries also need to have a mechanism to do age verification when processing data for the children. Right? Social media is a big factor, and they're going to have some laws for social media fiduciaries also, and social media platforms also. And let us see what the act finally comes in. Important issues is the penalties, right? So it is important for us to understand that if we do not do things, there could be repercussions, right? If we are a data fiduciary, we are control of the data of our employees, of our clients, we become a data fiduciary ourselves, right? So if not a fiduciary, we'll be a controller. So majority of the organizations would fall within the scope of a fiduciary or a controller, right? So because we have the data, we have employees data, we have healthcare data, we have clients data, we would even now they're trying to get the hardware manufacturers, which are hardware manufacturers who have the data which we still stored within their servers, in their systems and their environments as part of the bill itself, right? So that is another modification in the bill. Now, the fine they are saying is up to 15 crores or up to 4% of the turnover of the fiduciary, whichever is higher. So that is a deterrent. That is a factor that needs to, go up to the board of directors, that this is not an easy cup of cake, right? It is one of the most difficult things to do. Companies like Facebook, Google, and you name, we have seen the list of fines. They are facing challenges, specifically if you're owning an application. We will come to that as part of the privacy by design also. But if you own applications, if you have a lot of your own applications, privacy is even more difficult to do that, because it involves engineering life cycle change. It involves re-engineering your application, re-engineering the way you take the data and you process the data, you store the data across all IT layers, right? So it's important for us to analyze this and look at this factor always, that you could be liable to up to 15 crores turnover or 4% of your annual turnover, 15 crores penalties, right? So major requirements is the data protection officer. So significant companies, they will they will going to define who so or what is the level of turnover, etc. But they will be have to have a data protection officer with responsibilities of the key people. It's not that you will have a junior person, you'll employ somebody and make him a DPO. No, it says the DPO should be the chief executive officer, CEO, or the managing director, or the chief financial officer, or the whole time director, or the company secretary. So a responsible person who is responsible at the company can become a DPO, right? You can't employ a junior person and put him as a DPO and just get away with it. It may not be easy, right? Another important another aspect it talks about is doing a data protection impact assessment, right? So very few companies have in reality done a data protection impact assessment, because I'll tell you why it's difficult, because they need to go a step back first. They need to look at their data flows. They need to look at their data inventory itself, right? If you do not have a data inventory, if you do not know where your data is storing, you will not be able to do a data protection, data impact assessment, or the PIA, or whatever you call it, privacy impact assessment. There are several terminologies. So it is a long process, and it's not a process that in 1 or 2 months' time you will be able to achieve this privacy compliance. It may not be. So let us look at now how some of the requirements of the bill are mapped to action items, controls, and how they are related to even 27701. If you feel that this is going to be implemented, how it can be related to them, right? Looking at security safeguards, right? Like we just discussed, data fiduciaries need to implement security safeguards such as encryption, anonymization, de-identification, pseudo-anonymization, etc., etc. Right? Now, it relates to the privacy by design and privacy by default 7.4 section of the ISO 27701. So it already addresses that. We are talking of grievance addressal mechanism. Similarly, the 27701 talks about providing mechanism to object PIA processing, access correction, erasure, etc., etc. We're talking of age verification, right? Then again, 27701 provides us conditions to collect and processing and the mechanism to do that. If you're talking about data protection officer, it talks about the context of the organization at the entity level, who does what. Like we just saw, there should be a CEO level or the full-time responsible person to take care of the DPO. So it would come in the context of the organization of 27701 itself, right? Then we're talking about breach reporting. Breach reporting is, of course, which is a mandatory in data protection bill. Also, within 72 hours, you need to report the breach, right? And just I would like to point out again that this 72 hours is important. Recently, a large hotel booking platform or a travel booking platform was fined by GDPR under GDPR for not reporting a breach in 72 hours, right? So they have the powers. Whether they want to exercise that or not depends on the circumstances, depending on your luck, and depending on the case to case basis. I cannot comment as of now, but it would be in case to case basis. But my contention is, why do we want to give that opportunity to somebody which would involve that legal dispute or the process of these breach remediation, and of course that 15 crores penalty, whether it's to be levied or not levied, etc. In my opinion, prevention is better than cure. It's an old saying. When I was a kid, my father used to tell me, my grandfather used to tell me, try to avoid things. Prevention is better than cure. My doctor used to tell me prevention that is better than cure. That's the reason we wash our hands, we do all the required things, even to our personal life. Why? Because we don't want to get sick, right? Prevention is better than cure. Similarly, even when we apply that to privacy and to data security, it is the same rule that applies here also. Prevent it from happening, because prevention is less expensive, compliance is less expensive than legal disputes and remedies, right? So legal is expensive, and in the US we charge almost half of an auditor, right? Even in the US office, we charge almost half of the cost that our law firm charges us, even in the audit space. So legal costs are much higher than even the audit costs, and it would be cheaper for you to comply rather than get into the legal time, right? Then age verification, we did a DPO. We already discussed DPO requirement as part of the context. Breach reporting is done. Data privacy impact assessment, we just discussed that we need to do a privacy impact, and it is the requirement of the controls. And of course, 27701 also talks about doing a privacy impact assessment as part of the section clause 7.2.5. And data processor also is specifically mentioned in 27701, which has got a separate section on clause A number 8, which is a guidance for PISA processors, separate section, right? So then we talk about limitation on processing for personal data, and we need to limit that. Also, 27701 talks about 7.4.2 of limiting processing. We are talking of transparency, right, of the data itself that we collect. We also now talking of clause 7.2.8, record relating to processing of data. Entire 7 section, in fact, of the 27701 is applied only to controllers. The section entire 8 is applied only to processes, right? So what the processors need to do is covered under section 8 of the PIMS. What is applied to data fiduciary or data controller in terms of ISO is covered in 7.2. So whole section 7.2, limiting processing, the data transfer, conditions for collection, conditions for processing. The entire guideline is given in 27701, right? So accountability we already saw, and if you map that to 27701, it's already covered as part of 7.2. When we talk of de-identification as safeguards, we just discussed that if your data is anonymized, right, and you don't have any non-anonymized data, you may be out of the purview of the data protection bill or even GDPR, right? Then we are talking of 7.4.4 in 27701 as to what are the PII minimization objectives. How do we minimize data? How do we implement safeguards? How do we use encryption as a technology? Yes, of course. Then the requirements of keeping and record keeping and audits, right? The data privacy bill have provisions or has provisions as of now to have record keeping and getting audited. And if you see the relevant control in 27701, 6.5, which is a general control, even in 27001 has a compliance issue already covered, right? So whatever needs to be done from compliance standpoint is already covered in 27701 also. Although there are specific requirements or covers within the section 7, which is for controllers, and section 8, which is for the controllers, processors rather, right? Besides that, there's a general section for compliance also. In auditing of policies and conducting of processing, yes, we need to do a normal audit. We, as part of the ISO standards, we need to do an internal audit. We need to do a objective setting. We need to have an internal review. All those processes are already defined in the ISO standard, right? And you will update all your policies basis the ISO requirements automatically if you adapt this. Then processing personal data, again, we are having a section 7.4. We need to look at the privacy by design, privacy by default objectives to make sure that we have an entire collection, processing, retention, storage, the entire life cycle of data covered under section 7.4, which we're going to see in detail in the next few slides also. Data portability is, again, there is a requirement that companies will need to inform the data principal. They will need to take permission from the state if it's a critical data or it's a sensitive personal data, as in the next case, whether it's portability or transferability, it is not going to be easily transferred without permissions, right? So whatever there's a provision, there, whatever is the fine tuning going to be done, but there would be rather controls and requirements to take permissions for critical data, non-critical data, sensitive personal data, whatever they finally term it in the act. So again, if you look at the 27701, right, there have been controls in this in under 7.3, 7.5, and for cross-border transfer, so there have been controls identified under 27701, which is identifying the basis for transfer, etc. Now again, code of practice is a requirement. Code of practice is defined under the context of the organization, generally under the ISO standards, which is covered under 5.2. Consent is required from a data principal perspective, rights of data principals, limitation of collection of personal data, notice of collection of personal data, restriction to retention of data. Everything, all of this is mapped here to 5.2, 7.2, 7.3, 7.4.1, 7.2. I mean, these are just some references. There could be other multiple references also, because not only just one requirement, sometimes multiple references are aligned. I'm just giving one example to show that this is already covered under 701. Most of the requirements in the bill and which are converted into actions or controls are already covered under 27701. There will be multiple sections which are required, but I'm just giving one example because this is not a half a day session to look at all the controls and how they are relevant. This is just a high level discussion. Now coming to the standard itself, 27701, right? We all that the 27701 has been established in 2019, which is a PIM standard. The base is the 27001. You need to be certified first for 27001 to be certified for PIMS, right? That is the high level requirement. It helps to prioritize your risk and to manage the entire data lifecycle. You see that privacy impact assessment is covered, DPO is covered. Most of the requirements for most of the standards, GDPR and data protection will be covered. In my opinion, if you adopt any of these frameworks, SOC 2 for privacy also, or which is based on the AICPA privacy framework or the 27701, either way, right? Most of these frameworks are built on the requirements of the privacy principles by itself, right? If all the privacy principles are covered, right, whatever is the standard, whatever the compliance, you should be able to comply with most of the standards, GDPR or CCPA or New York Privacy Act or Colorado Privacy Act or even the Data Protection Bill. So majority of the controls would be addressed. There could be 10-20% delta which can be addressed specifically, but if you adapt these standards, right, you would cover majority of your compliance requirements. Again, it is based on the 27001 and now the 27002, which is now the updated to 2022 standards. We're going to have, as Alva already mentioned, we're going to have a webinar next week to discuss about that, what are the changes and how it would impact the 27001. But today we are going to discuss only about the PIMS and 27701. Now, some of the features are it aligns to information security, it aligns to operation management, it aligns to your physical and environmental security, it aligns to access control, HR, acceptable use, asset management, and of course, we have several additional privacy controls specifically relating to the controller and processor. As we've seen, the entire section 7 is relating to controller, and the entire section 8 is relating to the processor. Right? It is also the PIMS standard is also aligned to the ISO 29100 standard, also the 2718 standard, and also the 29151 standard, which are linked to privacy as guidelines and privacy in the cloud, etc. It 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 helps you compliance with the GDPR. It will integrate with other standards such as 27001. Of course, it's a base. PIMS has a specific guidelines in 27002. Of course, even the new updated 27002, the name has been changed to information security, cyber security, and privacy. So even the new updated 27002 talks about privacy specifically, right? Then it is aligned to the guidelines. We just saw 29100 guidelines for 27018, and of course the 29151 standards also, right? It's aligned, and it's a specific guidance to the data controllers and processors as whole sections itself. Now again, this is the extension of the previous slide. It's aligned to most of these frameworks, right? Just elaboration of the previous that we just discussed. One more quick point is 29134 is a ISO standard for privacy impact assessment. For privacy impact assessment, you could use ISO standard. There's a NIST privacy framework which you can use to do the privacy impact assessment, right? Which is also available, in my opinion, for free, right? ISO, you may have to pay for the standard, get it, but NIST is also available. You can follow any standards per se. Now coming to overall on the general standards, these are same standard as in the old current ISO 27001, right? And only the 5.2 will have additional contextual requirements. 5.3 will have additional requirements, and 5.2. And this is the same flow of the 27001. So I'm just skipping for saving some time and addressing specific areas. So this is same as the 27001. This is already aligned to that. The old standard may change when the new 27001 standard it is announced, but as of now, this is as per the old or current 27001 2013 standard, right? Now, important aspect is It's the same thing as for 27,001. I'm to dive deeper into this because of the paucity of time. Now I'm going to only refer to the clauses 7 and 8, which is specific guidance to PII as controllers. Now, if you see the as we discussed, the whole section 7 is an 8, right? 7 for controllers and 8 for processors has been defined as to what they need to do and how they need to do from a privacy standpoint, right? Identify, identify lawful basis, determine how and consent is to be obtained, obtain record consent, privacy impact assessment. We are having 3 more slides on impact assessment. Then contracts, joint controllers, records, determining and fulfilling obligations, determining information for PIA principles, right? Modifying the entire controls for the entire life cycle of privacy is defined for controllers, right? The whole section. So all of these sections are already covered in the clause 7 of the 27701. Now, if you look at the implementation, so clause, I think 8 is also here. Clause 8 also is, so let's finish the 7 first. I've also elaborated some of these sections in the clause implementation guidance to elaborate as to what you need to do to limit the collection, for example, right? What the organizations need to do to limit, what is the control that they need to implement, right? To limit. That's what is the control and how to do that. So there is the guideline available for all of these 7.4.1, 7.4.2, 7.4.3 to determine the accuracy, quality, minimization, de-identification, etc. Right? Temporary files, retention, disposal. So entire data lifecycle is covered under the privacy by design and privacy by default concept, which also is covered by the data protection bill. We just saw that. Now, if you have a data processor, the clause 8 applies to you. Also, it talks about specifically what you need to do, customer agreements, organization purposes, marketing and advertising use, infringement, customer obligations, the entire life cycle, data life cycle from a processor perspective is provided to you, which you can adapt and you can follow this structured way to come to compliance with either the data protection bill or GDPR or either the case may be. Also, just to further reiterate, we just discussed the old standard or the current standard of 27701, right, has NXA controls based on the 27001 standard, which may change in future, which is expected to come this year, but currently it is structured this way, right? NXS provides to mapping of the 29,100 controls. NXS E2F of the standard provides you mapping to the 27,018, which is a cloud security standard, and the 29151 standards. We also have mappings to control objectives of processors and controllers we just saw. NXD is mapping to the GDPR requirements. And also we have a reference to 29134 2017 standard, which is a guidelines for doing a privacy impact assessment. Of course, we need to keep in mind the general PDCA principle when doing a privacy impact assessment or the privacy management, which should be part of your entire risk assessment life cycle. So not only assessing the risk, monitoring the risks, implementing the risk, implementing the controls, checking the controls, monitoring the controls, whether they're effective or not, and of course, again, re-looking at those controls based on daily, weekly, or quarterly or annually monitoring. Just because you have and risk in your risk assessment sheet, right? You will not be able to mitigate the risk just because you have a control listed on that. You have to actually monitor and actually make sure that risk is mitigated. Just by putting on the Excel sheet, risk cannot be mitigated. If you think you have an Excel sheet and that control you have listed, this is first high and this is the control and becomes low, my risk assessment management is done. That is a beginning. Right? Many organizations feel I have my sheet. I have just because I put it on the sheet, my risk is mitigated. That is not the case, sir. That is only the beginning. That's not the end. Okay, so we have just to okay 1 minute to do this. We have only 2 more slides. So what do we need to do to implement and certify for 27701? First, let us look at the major benefits. Is it giving us benefit? Right? So the first major benefit is if you follow an established standard such as 27701, you will be able to establish an internal process for addressing privacy, which if you do not do that, it will go in a what do you say, in a non-organized way. We need to get it in an organized way. Why? Because we need to provide assurance to third parties. We need to demonstrate compliance. We need to help our internal and external auditors to showcase that we are doing everything required for privacy, not only from the ISO perspective, but from a data protection bill perspective, or the GDPR perspective, or the CCPA perspective, or any other law which may be applied to us if we are dealing in multiple jurisdictions, right? So the standard will help you to comply with many privacy requirements, and not just data protection bill of India, which is the 2021, right? So how do you implement and certify? So the first phase is to plan and initiate the project. You take onboarding, you have a consultant or a lead auditor to help you inside. You apply, you review submissions, you have a gap assessment, you complement the documentation development, you have awareness and implementation trainings, you implement all the documentation, you do a stage 1 and stage 2 audit. That's where you get the auditor formally on board to do the stage 1, stage 2 audit, then the certification and surveillance audit and the recertification as part of the standard ISO processes. So I think I've tried to cover what we can. And before I finish, this is a disclaimer that whatever we have said here is may or may not be applicable to you. So this is a disclaimer that whatever we said cannot be taken as a advice for your organization. This is a general talk. We are not specifically targeting your organization, or this advice should not be directly related to you or personally or your organization. That's what it means. And our email ID is here provided. If you want to reach out to us anytime, please feel to please reach out to us anytime. Okay, and I'll give back the control to Alva to take on the Q&A and polls.
Okay. Hi, everybody. I will just begin the polls right now. So you would be able to see that there are 4 questions, and the polls have already started. So please respond to the polls. Simultaneously, also, you guys will see there's a Q&A box. So we already have a few questions. So if you guys have any other questions, please put it in the Q&A box. Once the poll is done, I think we'll start answering the questions. So let's just take about 2 minutes. Okay, so we'll be starting the Q&A. Please, once again, just if you can complete the poll so we can quickly start with the question and answer session. So it'll just take like about a minute, just 4 questions. Please fill in the polls and then we'll start with the Q&A. I'll start addressing the questions and then Sir can start answering them. Also, if you guys have questions, please start putting them in the Q&A box. Okay. Yeah, so the polls are still open. Please, whoever has still not completed the poll questions, please just complete the polls. I think I'll start reading the questions and so you can start answering them. So first, we have 2 similar questions. One is can we share the slides after this session? So I think Yeah, once the session is completed, everybody, even the people who've attended or missed out, you all will be getting a recording of this session on your email ID. So you can refer to that. So now you can answer this question. May I know the difference between privacy impact assessment and DPIA?
Yeah, so the full form of DPIA is Data Protection Impact Assessment, and it is concerning the entire data. Privacy, you refer to only the privacy portion of it. So there's a thin difference. People use either or, and even the DPIA also covers the privacy also. So the D refers to the data and P refers to the privacy. Depends on what is your focus area, right? Next question.
Next is thank you for the session. Had a quick question on the second slide where we talked about the exemptions. Any reason why medical was put under exemption? There are a lot of PII in medical records, so did not
Yeah.
get that.
So I don't want to answer any legal questions of why or anything was excluded or non-excluded. Our focus here is finally when it comes to the act, what are the major issues and how do we put them into controls and how ISO 27701 can be used. I do not want to answer any legal questions of why this is removed or why this is not there. That is not the scope of our discussion today.
Okay. The next question is what is privacy by design?
Absolutely. Good question. Very nice. Privacy by design refers to, the fundamental question is why do you want to collect the data? When do you want to collect the data? What are you going to do with the data? What is the purpose of the data? How long are you going to keep it? Right? How are you going to take the consent of the people? How are you going to I mean process the data? Who is going to process the data? The entire data life cycle approach of your collection of before you collect the data should be defined and you should have controls. That is what it means. Privacy by design means before you start taking data. It's not that you give the form first, we have all the data with us, and then we'll think what to do with that. It doesn't happen like this. That's what is happening today. And that is what privacy by design aims to change the culture, that you just can't keep taking data from everybody without understanding the reason why you are taking it for it and without defining the retention policy, the period, the entire life cycle of the data before you take the data. How long do you need it? If you need it's a temporary personal loan, for example, for 1 year, right? And after the loan is over, you need to delete the data as part of the explicit consent. But you can't take my data, which was taken for a personal loan, and start marketing me car loans and housing loans and all other factors. That is what it means by privacy by design, in nutshell, right? As one example. Okay, next question.
Next is what will be the timeline to the organizations given by the government after DPO is passed?
I don't know. So let the act say that, and I don't want to do a guesswork as what is going to happen and want, because it's going to take time. But my thing is get ready now, because if the time is given by the government is 3 months, 6 months, 1 year, or 2 years, right? If you see the GDPR also people gave 1 year's time or maybe even more than that, but people are till date not ready, even after 3 years after the act coming into force, right? So don't think that you'll be ready overnight. Don't think you will be ready in 3 months. Don't think you will be ready in 6 months. You may take time depending on how big is your organization, what data are you controlling or processing, right? How many locations you have. It will depend on several factors.
We have a similar question, I think, which Sir answered. When is it likely for the Parliament to pass the bill? I think it's covered in what
Yeah.
Sir just said. What all important compliances are required for retail organizations?
Again, hold on. Can you repeat the question?
What all important compliances are required for retail organizations?
Retail organizations. It is not about retail or non-retail. If you have the data, right? Uh, all this are requirement. If you have any kind of data, if you have consumer data, if you have PI data, customer data, it's applicable to all organizations, all kinds of organizations, retail, non-retail, wholesale, right? And every organization stores some data, right? It's applicable to everybody.
Okay. Next question is, will data protection bill be flexible in India? Because data capacity in India is very large and organizations collect a lot of data other than the requirement.
See, as suggested, I don't want to comment on what they're finally going to do or what is the final act going to be or what is their thought process. Right? There is a committee, there's a joint parliamentary committee, is the discussion is with the committee members who are learned members, lawyers, technical, matey, everybody's involved. And I wouldn't like to, do some guesswork as what they're going to do, what is their thought process. Let us wait and let us see what actually comes out in the public in the forum, and finally what becomes an act. But most of these aspects which we discussed are going to be covered. It's my thought, my personal opinion.
Okay. Next question is, if I get certified as a lead auditor or implementer in 27701, does the training cover all privacy related standards?
So the training covers the 27701 standard, right? And how to apply. It may not cover all the laws, right? But you need to, as an auditor, as a technical person, you need to apply the standard for other laws, CCPA or GDPR or data protection bill, etc., etc.
Has the PDPB come into effect?
I think we just answered that, right?
Yeah. Do we make personal data register before doing DPIA?
That depends on what is your data, how you want to do it. The methodology can be discussed on a case-to-case basis. I will not be able to give you any general answers on that.
Okay. Other question is on data localization. Is this a mandate with respect to India DPR? Would service providers providing services for India but are physically outside the jurisdiction of India also be liable and getting covered under this regulation?
So there are requirements to that effect as of now, but what finally happens in the act, let's wait and watch. But as of now, there are localization requirements. There are thing. I don't want to extract the text out of this and do a legal discussion. As I just said, our focus is that there are requirements, and those requirements need to be converted into controls. And how can we use a standard such as ISO to comply with some of these best requirements, and not to discuss each and every clause within the law itself. That's the objective of this session.
Okay. Next is like GDPR, which came into effect on 25th May 2018. We will also have a timeline to implement once this is passed and becomes a law.
Yeah, of course, there will be a timeline, but what exactly? I think we answered this question. When it becomes a law and what is the timeline they announce? I don't know as of now.
Okay.
Let's wait.
Okay. How data security is different from data privacy?
A good question. Data is data, right? And now even because sometimes you cannot differentiate, right? And that is one of the reasons that the PDP has been changed to Data Protection Bill. Because sometimes there's a data which has PII content, which has non-PII content, also such as sensitive, critical, non-sensitive, and that is the reason they took the data protection. They renamed the whole bill into data protection bill per se, because one of that reason is this one, and that if you go through the document which is available online, the Joint Parliamentary Committee report, you go through all of those. It is one of those contentions was this.
What is the joint controller?
Joint controller could be, controller as defined in the PI 27001. Two people doing the same data, right? Two companies, different companies doing processing on the same data itself.
And we have one last question. If we have ISO 27701 certificate, then do we go for GDPR or PDPB also?
Okay, so let me reiterate what I've just said across the entire. And this is last question. We only 1 minute, so there are no. This is last question I will take because we need to end in time for the of course to respect everybody's time. Uh, the 27701 is a process that you are following to apply to the privacy by design and privacy by default concepts per se, right? Irrespective of GDPR or data protection bill or CCPA or Singapore privacy or any other privacy laws, because most of these laws are based on the privacy by design and privacy by default principles. So if you apply the principle, you will cover majority of the compliance requirements. I would say 60, 70, 80%, even 90%, depending on what those laws actually say. I cannot guess what each law is going to say in different countries, right? But I can at least say that 60 to 70 to 80% of these controls can be taken care of if you follow standards such as the ISO 27001 standards, such as even the SOC 2 for privacy. I think we are on time, right?
Yes.
And I think
Yes.
we should thank, if Alva, you can do the thank note, please.
Yes, so thank you so much again for attending today's webinar. We also have another webinar, as I mentioned before, on March 1. So it'll be great if you guys can join that. For registration link, please email us. And lastly, thank you so much. You will be getting a recording of this session. So yeah, thank you.